law students in history have taken this alternative path. If this Harvard Law student with us here today had not taken this more visionary path, we would never have had the Freedom of Information Act or the Clean Air and Water Acts. If this Harvard Law student with us here today had not taken this more transformative path, we would have smoking on airplanes and the word whistleblower would not have a popular use. If this Harvard Law student had not taken the more just path, we wouldn't have the Occupational Health and Safety Administration, nor the seatbelts and airbags that have saved millions of American lives. In an effort to begin our own, here in the audience, everyone here today, path towards similar transformative legal vocations, we present the founder of the modern consumer movement, the original Nader-Raider, the one-time host of Saturday Night Live, the only man to convince Sesame Street to have a song sung about consumer advocacy, America's chief public citizen and a hero of mine, Mr. Ralph Nader.
Thank you very much, Pete and Michael, and everybody at the Record who made this happen, and the Dean of Students who facilitated it. And thank you all for coming. I just want to recognize one person here in the audience, Jason Atkins, who graduated here in the same class at Barack Obama, and he's the chair of Public Citizen, which has a good litigation group and the Congress Watch, and has made a lot of changes. I suppose I should start by saying it's a lot easier than we think to turn this country around in many important redirections. Because we grow up corporate, we grow up looking at the world through thousands of ads, and we grow up with that kind of vision. And early on we think that it's really pretty impossible to take on the giants, so why not join them? And Harvard Law School obliges. Jury. President can be prosecutor, judge, jury, and executioner, all in secret. This should really disturb the Harvard Law School, since the president now is a graduate of the Harvard Law School. Former president of the Law Review. Law Review could be less interested in this. There's a lot of documentation that the violation of Constitution, federal statutes, Geneva Convention is not episodic, it's systemic, it's daily. The New York Times wrote an article called Killer Tuesday, when the president surrounded the White House with his security advisor, and they decide who they're going to kill. 3, 4, 5,000 miles away, including signature strikes, places like Yemen. A bunch of young men, they don't know their names, they're just huddled together, and they're considered suspects, and they're evaporated. Signature strikes. Not a ripple in the law schools, except there are a few stray law professors here and there who are very concerned about it. Well, let me put it all in a bundle for you. Should we be concerned about the following? Secret laws, secret evidence, secret courts, secret prisons, secret wars, secret torture, secret unauditable expenditures, redacted published judicial opinions. Imagine that. Redacted published judicial opinions, arbitrary state secrets defense against judicial recourse, routine violations of due process, probable cause, habeas corpus. That should be everybody's business, no matter what their specialty is, if they are a member of the legal profession. We should not be allowed to escape ourselves from what's going on in this country. When we were at law school, we were worried about Joe McCarthy and his intimidations, his slander, his red baiting. That was the big thing. Joe McCarthy, by comparison with what's going on today in your country, was a miserable sideshow by comparison. Look at Guantanamo. Look at our prisons. Look at our solitary confinements. I look out at the students here, and I'm saying in the back of my mind, what a wonderful diversity. You have women, men, minorities, not as many as you would like, but compared to the 50s. What's the value of that other than equal opportunity for an upwardly mobile career? defined by male standards. You go into the corporate law firms, defined by male standards. You go to the Department of State, defined by male standards before women and minorities ever got in there. What's the point? What do you bring to the profession, to the country, to the world? Because you're part of a breakthrough diversity corps. What do you bring to it? Well, you might bring more sensitivity to certain women's issues, reproductive rights, daycare, but in the all-encompassing corporate domination of our society, all-important deterioration of our democracy, we all have to put another burden on our back if we were from excluded groups, so we can tutor the dominant groups. There's always a rationalization. Oh, it's not my specialty. I'm not into presidential powers. I just deal with bankruptcy. Well, you know, Dean Irwin Griswold was a tax lawyer here. He was a tax professor. And he was one of the first deans, and you can't believe the courage this took, to publicly challenge Senator Joe McCarthy. He didn't say, oh, I'm a tax lawyer. I've just got to deal with tax issues. Watch for those easy rationalizations. The key point is that if the law school does not reinvent itself, if it does not split into two curriculums, one, the normal servicing of the commercial economy, you want to do that, fine, and the other, servicing civic values, servicing justice, servicing fairness, servicing shift of power, servicing modes of organization of the citizenry, servicing electoral reform. That's what needs to be done. We need thousands of lawyers who do this as lawyers, who take their conscience to work, and who begin to reshape power. Otherwise, all you're going to see in the coming 50 years is a few breakthroughs here and there, but by and large, the drift of global corporatism is concentrated power defined by commercial standards and values running roughshod over the far more important civic and spiritual values that spell a civilized society and a world. Every major religion warned its adherents not to give too much power to the merchant class. What did they know? Was it something conveyed to them from on high? Or was it reflecting common experience? That the monomaniacal driven motivation of the profit instinct brooks no challengers in its mission for aggregating profits. It will diminish, control, co-opt, or destroy other value systems that are nowhere near as well organized. That's why every major religion issued those warnings. So what would I have Harvard Law School do once they break into these two curriculums? Once they redefine their mission, which is justice, what would we have them do? We would fill the courses, all of them, with empirical reality. The courses are heavily empirically starved. That's not true for your clinics. It's not true for some of your courses. It's not going to be true for Professor John Hansen's course on systemic justice. Probably not true for Roberta Unger on building democratic societies, or the omnipresent Lawrence Lessig on campaign finance reform. But by and large, the courses are not reflecting what's going on back on the ground. The second thing that Harvard Law School should do is redirect massive resources into justice, either by its leverage, prestige all over the country with alumni, as well as with foundations and other sources of money. You know, you have nanotechnology coming, biotechnology coming, artificial intelligence coming. They have no framework, no legal and moral framework. No legal and moral framework. When Bill Joy of Sun Microset wrote his fabulous article in Wired magazine in 2000, the title was "The Future Doesn't Need Us." And what he meant was that unless we bring under control Whatever. We may disagree how. Artificial intelligence, biotech, and nanotech. The future is not going to need us because they're the future, autonomously. Now, the Harvard Law School class of 1958, our class, got together at one reunion and said, why don't we do something other than talk about our practice? And most of them were corporate lawyers. I felt a little lonely. But we knew each other when we were law students. There was a cohesion there, a familiarity. And we started the Appleseed Foundation. And we funded it. It now has started 16 centers for law and justice all over the country. That's one law school class. By the way, it was not exactly encouraged to talk with other alumni reunions by Dean Clark when he was in charge of the law school. But now I guess they have good access. My expressions are conveyed as an invitation for collaborative introspection by you and your faculty. And you have some very good faculty for that purpose. Look forward. Be your own stare decisis. Start your own revolutionary traditions. In the spirit of Thomas Jefferson, who suggested that maybe there should be a revolution every 15 years for unresponsive governments. I don't think he was talking about violence, but you know what he was talking about. Supplant your campus small talk with big talk. There's nothing more irritating to some of our generation than to walk through law school campuses and never be able to look at a law student in the eye because they're all like this. This is devouring you. Think of the implications of looking at screens and endless text messages that have minimal gravity. Think of the implications, hour after hour. Look up from your stupid smartphones and see the horizons before you. Experience the life of joy and justice. Avoid like the plague of minding yourself in rigid routines daily that draw even tighter circles around you. Start a visiting victims program in your classes. Have them sprinkled through your class, 3 or 4 out of 80, visiting for a few days. Absorb their reactions from their very different perspectives. What would happen in your labor law class, or in your civil rights class, or in your consumer classes, if you had in your course, in the classroom, visiting injured workers, migrant workers, defrauded debtors, malpractice patients, excluded investors, child custody nightmares, falsely convicted inmates, refugees from America's empire, dissenters jailed without charges, people in solitary confinement, farmers driven to the wall by oligopolies, homeowners underwater due to Wall Street crimes, pensioners fleeced by their employers, punished whistleblowers from giant corporate law firms and national security agencies. They're all willing to come. And we're not talking about anecdotal phenomena here. We're talking about refugees from systematic patterns of injustice. You can add your own list. A visiting victims program. Leave Harvard Law School very different than when you entered it. Take the Harvard Law parallel to the Athenian oath of citizenship. In these Periclean Athens, they took the oath to leave Athens better off than they entered it. To know and not to do is not to know. That came out of the 14th century philosopher in the Ming Dynasty. Just think of that. To know and not to do is not to know. On the other side of the world, Marcus Cicero gave us what I think is the best definition of freedom. He wrote, "Freedom is participation in power." How many times do you hear that context? How long is it going to take for us to catch up with Cicero and this Chinese philosopher? How can you, chosen to journey through this high citadel called Harvard Law School, from among the thousands of applicants who were rejected, not have a higher estimate of your significance, soaring beyond the ceiling and the selling of your talents for lucrative trivia or worse. In the coming days, a book collection of wise and experienced recent submissions to the Harvard Law Record will be available in print. In print, by Joe. Imagine, for you to digest. In the coming school year, the record wishes to be your vibrant forum for going valiantly where few law students have gone before. Connect with the students there. Write for them. Stand on the shoulders of your most illustrious forebears, your courageous forebears, who changed what I described in the 50s. So much for the better. Catapult from stagnant silos or corrosive cocoons into making the improbable here possible. The lawyers of this country and the people of this country need you. We're not engaging in exhortation and generational flattery. We need you. We need your idealism. You may not know it, but the legal profession often looks at students at law school as their conscience, having no axe to grind. They can tell it the way it is. The sum and substance of legal education and its ultimate intellectual challenge has got to be the realization of legal systems furthering justice and fairness for all. Back to Robert Hutchins. What is the purpose of the Harvard Law School? If you like some of these remarks and they generate some discussion in the coming days, I suggest you establish an ad hoc committee titled the Harvard Law Students Committee to establish a committee of inquiry and resolve. That's a nice phrase, I think. The Harvard Law Students Committee of Inquiry and Resolve.